Trying to get a green card for a spouse that entered the United States without permission, there's some extra steps. You're going to need something called the I-601A waiver. This is Joseph Patrick Murphy. I'm an immigration attorney with Allegheny Immigration Group. My practice primarily involves family-based and humanitarian immigration, and family-based immigration often includes the use of waivers. There are a lot of people in the United States who entered illegally, unlawfully, that is, without a visa, and then married U.S. citizens. This happens all the time, and there's a procedure for that, and it's called the I-601A waiver. Because your spouse entered without permission, they're what's called inadmissible. Now, they're already in here, so it doesn't really matter that they're inadmissible. The problem is inadmissible people not only cannot be let in the United States, but they can't get or change status. They're not actually here. As a matter of law, while they're physically here, as a matter of law, they're not here. So inadmissible people, in order to get status, have to go home, get the right type of visa, and re-enter the United States. The problem is that because they entered without permission, they're inadmissible. So if they leave for any purpose, they won't be let back in. So it's a catch-22. What you have to do is get a waiver. This is a forgiveness of the unlawful entry before the spouse leaves. And that waiver is applied for on the form I-601A. There are some requirements, and that's what this video is about. I'm going to talk to you about what's required to get that waiver. And I've got the list on my screen. I'm going to go over it with you. The person who needs the waiver must be at least 17 years old. They must be physically present in the United States. They have to already be in. They have to have an immigrant visa case pending. That means there should be an already filed or filed at the same time as the 601 and I-130. That's your petition for alien relative. They can have no other inadmissibility issues. So the only reason that they are inadmissible has to be immigration violations. It can't be inadmissible because they did crimes or some of the other reasons they're inadmissible. It just has to be either massive overstay or they entered without permission. They can't have a deportation against them. That's another one. If there's a deportation pending, you can't file the I-601A with USCIS because immigration court would have jurisdiction over the non-citizen at that point. They can't be under an order of removal. They can't have been ordered deported. And finally, they must meet the requirements. And again, the requirements are that they entered without permission. So that's the rule. Now, the other thing is the extreme hardship to the qualifying relative. You can't just apply for this and get it. It's not like applying for a driver's license or a work permit. There's actually an argument. You have to demonstrate, you have to persuade immigration that your citizen relative, the citizen, will suffer a hardship, extreme hardship, if the non-citizen is ordered to go home. I've got some examples of extreme hardship here. I guess the most commonly used hardship is a health condition, okay? Where the citizen is, for example, stuck in a wheelchair and needs the non-citizen to help them get around, or where the citizen has a psychiatric condition and they need their spouse to cope with the world, or where the citizen has epilepsy or some horrible condition. It also could be a hardship to the citizen if the non-citizen has the condition and the citizen would have to go to the home country to help them manage the condition. That's the other type of hardship. But the law requires, in order to qualify for the extreme hardship needed to get the I-601A waiver, that the hardship has to be more than simply separated from your spouse, okay? The law, it actually says that. It has to be something more, and that's what they mean by extreme hardship. Other examples of extreme hardship could be a situation where the spouse loses access to the U.S. courts, okay, if there's a child custody dispute or something with a prior spouse. Lack of language skills, where your non-citizen spouse who illegally entered doesn't even know the language of the home country. Things of this nature, there's lists of these things online, but the most commonly used one is a medical condition. Now, in order to get you this waiver, I have to prove more than just a medical condition. I have multiple cases right now where the clients want an I-601A waiver, and they just mailed me some medical records. I'm not a doctor, I don't know what those mean, and neither are the people at USCIS. Even if I did know what they mean, I'm not qualified to tell the people at USCIS what they mean. Only a physician is qualified to read and write reports about medical records. So in addition to your medical records, you're going to need a report from a qualified medical professional explaining how the deportation of the non-citizen spouse would be a hardship either to the citizen or to the non-citizen spouse. It can't just be, oh, here's my medical records, get me a waiver. These things, it has to be like a whole production. There's like a small book almost Last one I did was about 70 pages, where you're explaining the good character of the non-citizen, the fact that the non-citizen's never gotten arrested, the fact that the non-citizen is a good guy or good girl, and that the non-citizen has this infirmity or vulnerability that would make a hardship either for the non-citizen or the citizen. But the point is you can't just send me medical records or tell me that one or the other of the spouses has a medical condition. I need the proof of the medical condition, and I need proof that separating these people will work a hardship on the citizen spouse, either because the citizen spouse needs the non-citizen spouse to help them, or because if the non-citizen spouse with the condition is sent home, the citizen will have to go there and help the non-citizen. So that's the rub of this, okay? I've got a couple cases now where people either only gave me medical records and expect me to somehow magically turn into a doctor and write a report, or they only told me they have a condition and never gave me any proof of that condition. If I don't have these things, the case is just going to sit there. And you're going to call me back in a couple months and you're going to be frustrated because I haven't done anything. The reason I haven't done anything is because I can't. I don't have what I need. So that's the issue, right? You're going to have to prove that's the part that these things are litigated over. Being 17 years old is easy enough to prove. You can prove that with a birth certificate. Being physically present, you can prove easily enough. They can go to an interview. Have an immigrant visa case pending. That's also easy to prove. You just attach a copy of the I-130 receipt. No other inadmissibility issues that you would know as the non-citizen. You would know if you have other inadmissibility issues, not in removal, not have already been removed, and so on. So those things are all easy. They're either yes or no. There's no real argument. But whether a condition is a qualifying hardship requires proof of the condition, and then also medical proof that this would cause a hardship, generally to the citizen, but sometimes generally to the citizen directly because they'd be deprived of the services of their non-citizen spouse, but sometimes to the citizen because they'd have to go home with the non-citizen spouse and help care for them. So that's an example of the I-601A, and those are the points that people fight over. The big thing people fight over with me is the price. These are a lot of work, and they're very expensive. Unfortunately, when the spouse enters with a visa, it's quite an easy process, and a lot of times people who need a waiver are talking to people where their spouse entered with a visa, their spouse never entered illegally. That process is pretty straightforward and simple. But where the spouse enters without permission and needs a waiver, the process takes much longer and costs much more money. We can talk about price. You can call me. I do that kind of work. My name is Joseph Patrick Murphy. I'm an immigration attorney with Allegheny Immigration Group in Pittsburgh, Pennsylvania. I handle waiver cases all over the United States, and I'd be happy to talk to you about yours by cell, text, WhatsApp, and Viber. All the apps, all the chats, they're all the same number, 412-973-3442. You can call me. That number rings right through to me, and I'll be happy to take your call. People call me all the time, and you can too. Joseph Patrick Murphy, 412-973-3442. Call me with your I-601A waiver cases. No charge to call and talk to me. I'll be happy to talk to you. I look forward to hearing from you. That's the thought, though. These are expensive and time-consuming, and I'm going to need a lot of help from you. It's not something you can just give me money and a couple pieces of paper. But if you do cooperate, I can get these for you, and we can get that green card for your non-citizen spouse. This is Joseph Patrick Murphy with Allegheny Immigration Group. Thank you for watching.